Because by the time she gets to the end of what she's saying, I may not remember my question. So if you say after probable cause, if I ask after probable cause, then what's the next thing?
Right out the gate, we're dealing with over $32,000 in unpaid child support. Defense argues for bond relief so he can start a new job, but the statute demands 25% cash. Will good cause save him? Subscribe for sharp courtroom breakdowns and real legal drama.
Good morning, Judge. My name is Alan Cooper for Joanne Crawford.
Your Honor, good morning. For the record, Mark Burke, P54935 with the Attorney General's Office appearing for the people.
Same, sir.
Joanne Crawford.
Your Honor, it is our ultimate intent to try to waive this exam, although I haven't actually had an opportunity to speak with my client about it. I was wondering if perhaps we could maybe address the issue of bond so I could have a better chance to meet with him and then have a better conversation with the prosecutor.
Well, that may not, I mean, you can argue it, but I think his bond is set pursuant to statute in this case at 25% of what he owes. So
yeah, I understand that, Judge. I think that sometimes that it's overlooked that the statute does require a good cause exception. I understand that it provides for.
Oh no, it's not overlooked. I look at that every time.
And the issue
So
is,
if you want to make your argument, go ahead and make your argument, counsel.
Okay, great. Well, the thing is, my client does have a job that's waiting for him on for February 17th. So obviously, the whole point of this case, the child support case, is to try to get money and get payments to try to get his arrears paid down. So that's a real truck in Ann Arbor. I actually do have a copy of the letter showing his job offer. So he's supposed to start there on February 17th. So our hope is to get at least some kind of bond, so that way he can start working. So that way, obviously, at some point we're going to negotiate this case, and it's going to involve payment of some money. So he can't do that if he's not working. So I don't want him to miss this opportunity for employment when it's right there waiting for him. So he does have the family in the community. His mother's supposed to be there at court. I just got off the phone with her. She's at the courthouse. He's got substantial family in the area. So I would ask for a personal bond. He takes care of his father, who's an amputee.
I'm sure, counsel, that he was working at some point before his child support got to over $25,000, right?
He was unemployed for a substantial period of time, and he tried to file some motions to modify his child support over the last year or two, but he tried to do it improper. So of course he didn't get a proper hearing date. So our intent is to backdate that, and we're going to go through the civil court as well. It's not going to completely reduce all the arrears, but it's going to have some reduction if we can go retroactive back to the date when he first filed those, because he was unemployed for a significant period of time. But the problem that I have is that he's got this job waiting for him. I don't want to miss this. I don't want him to miss this opportunity, especially when he's going to have to end up paying something towards some arrears.
Any response from the people?
Your Honor, thank you. The only thing I would indicate is the court is certainly well aware of the statute. It's 750.165. It does require 25% cash bond in the amount of the arrearage. Judge, the arrearage currently, as of 2 days ago, is north of $32,000. The bond that I see, that I believe is that's ordered as $63.95. I mean, quite frankly, it's probably low compared based on what the arrearage is today. But the other thing also is I appreciate counsel's argument that he wants to work and he wants to start paying. But the reality, Judge, is the defendant has an ongoing obligation of $555 a month right now. He's paid a total of $1,500 in the last year. That's it. So, I mean, and I don't think he's been in custody that long. So, in any event, I mean, I'll leave it to the court's discretion, but a PR bond is definitely not within the statute. So that's a good position.
I think the statute specifically does provide for a good cause exception. I think the fact that this case is a nonviolent offense, it's financially.
I don't find good cause, counsel. He's now, the bond actually is low of the 25% because we set it based upon 25% of what's in the complaint. from the time of the complaint till now, he obviously hasn't paid because that amount has grown by almost $7,000. And so there hasn't been anything paid. I in this, and don't find, based upon the argument, a good cause exception to the 25%. I won't raise it based upon the number given by the state today, but I'm going to leave it where it is, which means it's going to be lower than the 25%, but something's got to be paid on this. So motion for bond reduction is denied.
All right.
As to this case, what do you want me to do with it?
Well, personally, I'd like to waive the exam. So we're fine waiving the exam.
Well, does your client want to waive, or does he understand what that is?
I haven't had a chance to speak to him yet about that, Your Honor.
Probable cause conference will be adjourned 1 week out. February 19th, 2026, 9 a.m.
Thank you.
Sir, he'll talk to you and then we can figure out where we're going. Understood, sir?
Yes, sir.
Thank you.
Your Honor, thank you.
Bond continued. Thank you.
Mr. Cooper, thank you. If you want to talk, give me a call anytime, okay?
Thank you,
Court
Mark.
calls the case, People versus Tyler Oliveira.
Assistant Public Defender Ben Dunaway on behalf of Mr. Oliveira, who should be appearing on Zoom from MDOC.
Yes. But we got to get him unmuted. Oh, he is. Mr. Oliveira, could you state your name, please?
Tyler Oliveira, can you hear me?
Yes, sir, we can. Thank you.
Okay.
What are we doing?
Your Honor, this is Mr. Oliveira's first court appearance. I have not yet been approved by MDOC to meet with him, but I did request so on Monday. Defense would have to ask for 2 weeks to meet with our client.
Probable cause conference is the 26th going to be enough for that to happen? Or am I going to get here and adjourn again?
Wait, don't turn the form in?
Pardon?
Do not turn the form?
No, is that going to be enough time, the 22 weeks? Is that going to be enough time for you to get approved, meet with your client and do something productive? Or do you need an additional week?
We'll take 3. Thank you, Your Honor.
Probable cause conference, March 5th, 2026, 9 a.m.
Thank you.
Bond continued. Yeah.
Thank you, Your Honor.
So what is that? Is this Ms. going to do?
No.
No. Court does call the case, People versus Brian Laster. He's not going to read it.
Correct.
Which one?
The last
Attorney Feaster, Assistant Public Defender on behalf of Brian Laster. Mr. Laster, how are you?
I'm fine, how are you?
Good. Please state your name for the record.
Brian Ian Laster.
Thank you, Judge. I did reach out to the prosecutor on this case. We are working on trying to get a resolution to this file. To date, we have not yet resolved it. Hopefully, we can come back in the near future and get this matter resolved. Be asking for a brief adjournment, Your Honor.
That's fine. Do you realize he has another case?
I did not, Your Honor.
Been rather sort of a cluster getting it here because we're not sure what happened, but we have a duplicate.
Oh,
It's a charge of larceny in a building, the 4-year felony.
okay.
I'll give you the case number. It's 26F5 5030.
Okay. Thank you so much, Judge. I will include that in my
Pardon?
I will include that in my discussions with the prosecutor.
I was told
All right.
I was less than $200. In the charge I'm here for now, I'm not aware of what the charge is here for today.
Okay.
I was adjourned, I was
Okay.
and the $200 from a
Let's not
mill.
talk about the
Well,
facts of the case.
hold on, Mr. Laster.
And this charges, this stipulation charges are
Mr. Laster, I'm going to ask you to be quiet. I don't want you to say anything about the case at this point. And certainly counsel doesn't know about that. I'm just going to, why don't we just go through the arraignment on this? Mr. Laster, the complaint alleges that on or about November 8th, 2025, location of 210 South First Street in the city of Ann Arbor, Washtenaw County, state of Michigan, that you did commit the offense of larceny in a building. Specifically, it indicates that you did commit the crime of larceny in a bar or public house by stealing from the cash register drawer, and stealing from the cash register drawer cash, and then 3 bottles of High Noon seltzer, contrary to Michigan statute. I'm not asking whether or not you did it or not, but do you understand what you were charged with?
Understand?
Excuse me. Yes, I understand.
All right.
And,
That's a felony punishment by,
business was afforded to.
pardon?
The guy across the street.
Let's not talk details of the case today, because Anthony said he's finished.
Already.
So you understand what you're charged with,
Yes,
sir?
I do.
You understand that that's a felony punishable by up to 4 years incarceration
Yes, I
and a
do.
$5,000 fine plus court costs.
Yes, I do.
Do you wish to be represented by an attorney?
Yes.
Mr. Feaster, take over, please.
Thank you, Judge. Torrio Feaster, Assistant Public Defender on behalf of Mr. Lester on the new file. Laster on the new file. Your Honor, we would waive any form of additional reading and we would stand mute, Your Honor.
Defendant, every way from a reading standing mute, court will enter not guilty plea. I will set probable cause in this case. How much time did you need on the other matters?
Just a couple of weeks, Judge. We had a fairly decent offer.
Right.
Maybe we can incorporate that.
That's fine. I'll set a probable cause conference for February 26, 2026, 9 a.m. As to his bond in this case.
Your Honor, I believe he's had the bond in his other cases.
Pardon?
I believe he had the bond in his cases he's in for right now. I'd ask for a low bond on this one as well. Just getting credit on everything.
Well, what's he in on? I have 1,000 cash or surety on one of them, and one of them also he has a personal recognizance bond.
Now the focus shifts to a larceny in a building charge, cash register money, and 3 bottles of High Noon allegedly stolen. The judge sets a $5,000 10% bond with strict conditions. No alcohol, no drugs, and stay away from the location. Freedom comes with boundaries clearly enforced.
Yes, that sounds right, Your Honor.
Pardon?
That sounds accurate.
All right. What I'll do in this case, I'll set his bond. He's got other cases, so I can't do. I'll set it at 5,000, 10% at this point. Other standard conditions, including no assault behavior or possession of any weapons. You're not to possess any alcohol, recreational marijuana, or any illegal drug. I will also indicate that he is not to enter 210 South First Street in the city of Ann Arbor.
Thank you very much, Judge.
Thank you.
Thank you, Judge.
You're welcome. Court does call the case of the people versus Margaret Petoskey. Well, where's Miss Gaines? If I.
Oh my God.
Ms. Gaines?
Pardon? Well, yes, because she's the one. Pass it briefly. Court does call the case of the people versus Jayla Allen. Jayla Allen.
Good morning, Officer Charlotte Stefan on behalf of Ms. Allen.
Morning, your name?
Jayla Allen.
Jayla.
It's okay.
All right.
Your Honor, I was just appointed last night to this, so I'm requesting an adjournment. Would 4 weeks be okay with the court?
Probably not, but you need 4 weeks.
Yes, Your Honor.
Hearing no objection, probable cause conference will be adjourned to March 12th, 2026, 9 a.m.
Thank you
Bond
very
in
much,
this
Your
matter
Honor.
will continue. Thank you. Court calls the case People versus Cadena, self.
On behalf of the people, Your Honor.
James back.
Good morning. Good morning, Your Honor. Christina Saxon from the Self. Please state your name for the court.
Kadena Self.
Thank you. What are we doing?
Your Honor, would like to make a bond argument and set this for preliminary exam.
Discovery is complete.
To my knowledge.
What date are we in? People have their witnesses available the 24th. Preliminary examination in person will be set February 24th, 2026, 9 a.m. before Judge Barr. As to bond.
For Ms. Self to be released on tether. Since the last time we were here, I've learned, excuse me, that the alleged victim in this case has been arrested and charged. When we were here last time, her arm was in a cast, and that was from a domestic violence event with him. They do not reside together, so I'm asking for a release with a tether. And in addition, just to show
Do you
that
think something has changed since the last time I denied bond?
I have more information about that, the fact that you only heard that there was a stabbing. From the looks of this, it actually warrants me having it looked at to make sure that he had not done that based on the angle of the marks. So, yeah, that has changed. It's a presumption that warrants more consideration. And on a side note, she wanted me to let you know she completed her GED for language arts yesterday. So she has used her time in here so far wisely.
Response?
Your Honor, I would object again that previous case that was mentioned by Ms. Saxon was dismissed, I believe, 2 weeks ago. The facts that I brought to the court before I leave, I also put these issues out with intoxication as well. So at this point, I object.
Motion for bond reduction is denied. Bond will continue. Take a look at it again. Thank you. The court does call the case People versus Kobe Fletcher.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Fletcher. Mr. Fletcher, could you please state your name for the court when you get up here?
Kobe Fletcher.
Judge, hoping for an adjournment to review discovery.
That objection, probable cause conference, March 5th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Bye. Does call the case People versus Edna Grima.
Good morning, Your Honor. Charlotte Steffen on behalf of Ms. Girma. Your Honor, unfortunately, there's been a breakdown in the attorney-client relationship, and I have to ask to withdraw from representation.
Your name?
And the girl, may
What?
may I be allowed to speak, Your Honor?
Go ahead.
Okay, Your Honor. I couldn't have. Wait a minute. Okay. Excuse me.
Bless you.
Thank you. I couldn't have a regular, attorney from public defender because it was conflict of interest or whatever. So
Right.
I have from the county, right? Okay. Your Honor, my question is, if I request, or if I ask the no probable cause to be handled right here, right?
If you ask for what?
If I ask her,
Okay.
Okay, let's just put it like this. She and I were talking, and I was stopping her to ask her questions to
Okay,
make sure I'm following her.
okay.
And she didn't like that.
She didn't like what? That you asked a question?
Yes, sir. She said, if you stop me one more time while I'm talking, then I'm going to get up and leave. Your Honor, I'm 61 years old, okay? I have to ask the
So
question.
you're gonna tell me that Miss Stefan stopped you without cause to stop you,
What?
was trying to, as she's trying to explain things to you, and that somehow or another that did what to you?
No, what I'm saying is that she was explaining her thoughts on, she was telling me what she was going to do, right? As far as the case. And I was stopping her to make sure I understood what she said, is what I was doing. She didn't appreciate me stopping her while
Or what she was telling you is, let me get through what I'm gonna tell you, and that then I can answer your question.
but I have a hard, I, I'm trying to follow her as she go along, sir. That's all I'm.
That's what?
I was just trying to follow her. I'm trying to follow her as she goes along, because by the time she gets to the end of what she's saying, I may not remember my question. So if you say after probable cause, if I ask after probable cause, then what's the next thing? See, never mind. First of all, I just want to say, I beg, I pray to God in Jesus' name, and I'm praying right now.
Man, what do you want me to do?
I'm asking you to please forgive me, find grace and forgiveness for me breaking my bond thing, as well as I have a nonprofit youth organization. My nephew was killed in 2021.
Ma'am, right now,
Yeah.
your attorney has said there's been a breakdown in the attorney-client relationship.
This is tense. The defendant apologizes repeatedly, but the issue isn't emotion, it's communication breakdown. When counsel says representation can't continue, the court listens carefully. Withdrawal is granted, bond remains revoked, and new counsel will be appointed. In court, clarity and cooperation matter more than passion.
I don't understand.
You don't understand that? So you don't, well, you got up there trying to be critical.
I kind of do
You kind of do what?
understand it, because she and
Do
I.
you want Miss Stefan to represent you or not?
Do I want her to represent me? She don't want to.
I don't think Miss Stefan has ever turned anybody away. You need to listen to her, though.
What did she say?
What do you mean, what did she say? To me?
Yeah.
She just said there's been a breakdown in the relationship, but I'm trying to understand that.
So now what? I'm just confused. I don't understand.
Maybe that's why when your attorney comes to talk to you and she stops you, she's trying to make sure to explain everything to you.
Okay.
Which means you have to listen.
Okay.
So what do you want me to do?
Forgive me for breaking my. Do I want her to be my attorney? Is what you?
Well, that's where we need to start.
Okay. Do you want to be my attorney? Do you think we can work it out?
Your Honor, with all due respect to the court and Ms. Girma, I do feel bad about this, but I don't think that it's at this point fair to Ms. Girma to have me continue to represent her, because it got, in my opinion, it got to such a point that I'm here now asking to withdraw. And Your Honor, I probably have. It's very rare, if ever. So Ms. Girma deserves an attorney that she can effectively communicate with. I'm certainly willing to try, but I just don't think that's in her best interest at this time, Your Honor.
Yes.
So would you please forgive me for breaking the bond thing and please?
Ma'am, I'm not even dealing with the bond. I'm trying to make sure you have an attorney that you're gonna listen to and can communicate with. But if Ms. Steffen is coming before this court, I don't think she's ever withdrawn a case before me and asking or believing that she cannot properly represent you. I'm gonna take her at her word.
Okay.
So what I'm gonna do is we'll need to have I won't require a written motion, which I normally do to withdraw. I'll take the oral motion to withdraw as granted. Ma'am, what I'm gonna do is, since I doubt the MAC office knew about it, I'm gonna adjourn it out 1 week so that they can have time to appoint counsel to present you. So the probable cause conference will be adjourned to February 19th, 2026, 9 a.m. At this point, your bond was revoked. Your bond will continue as revoked until we can get through everything. So our bond will continue revoked. Thank you.
Thank you, Your Honor.
You get to, yeah. Court does call the case, People versus Edward Bryan.
All right, good morning again. For the record, Mark Burke, P54935 with the Attorney General's Office, appearing for the people.
Oh boy, here we go.
Good morning.
You good today?
I am good.
Okay, go ahead.
Good morning, Your Honor. Monica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Attorney Stephanie Cannon.
All right. Permission to practice is granted.
Thank you, Your Honor. We would like to adjourn this matter.
Is she here?
Oh, sorry.
No, I didn't hear noise in the room, so I figured Cannon wasn't here. But
Just walked out.
I'm talking about the defendant. Vern, can you state your name? I don't.
He's on Zoom, Your
Okay.
Honor. Looks like he's muted.
Mr. Okay, there he is. All right. All right. You're
Oh,
asking
yeah,
for
sorry. Good morning, Your Honor. I was muted. Sorry. Good morning. Sorry.
what? All right, we got you.
Okay.
So you're asking for an adjournment?
Yes. Until after around like March 19th, if possible.
To March 19th?
Yes.
What's
I have
gonna
a friend
happen
of the
then?
court hearing on past payments for arrears on March 6th, sir. It was
Well, thanks
scheduled,
for
but
interjecting. Okay, what?
I had a meeting canceled due to the weather up there on past payments on my arrears. It's rescheduled for March 6th at 10 a.m. through friend of the court.
So counsel, the reason that you're asking
The reason
is
that
because there is a hearing
yes.
and you're waiting for time for the results of that hearing to happen, and you think that will happen by March 19th.
Absolutely.
That's what you would have told me had you not been rudely interrupted.
Exactly.
Okay.
Yes.
Oh, sorry. Shoot.
Do the people have any objection to an adjournment to that date?
Your Honor, the defendant posted bond. People have no objection to that. That's fine. As long as the defendant waits the 21 days, which I assume he already
Yes,
has.
I think they already have on the form they have. All right. Probable cause conference will be adjourned March 19th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Your Honor, thank you very much. Have a great day.
All right, you do the same, sir.
Thank you.
Court calls the case, People versus Tanvir Ahmed.
Assistant Public Defender Jay Bellinger on behalf of Mr. Ahmed, who approaches, Your Honor. Good morning.
Good morning.
Can you please state your name for the record?
Tanvir Ahmed.
And Your Honor, we are just asking for a 2-week adjournment as we are in the heavy throes of negotiations.
Could I make a finding on this already?
Your Honor, I didn't see one in my files. So I did submit one because I saw that the last report came in on 2-3 and I just wanted to
On
make sure.
what?
On 2-3, that's when it was uploaded to my file for him. I just didn't see one in our file that had been given to the court. So I do apologize if there's been a second one received.
Well, no, I have I don't think there's been a finding on competency at this point.
I think that we need to do that first and then.
Yeah, well,
Apologies.
that's what I'm saying.
Okay, I apologize.
So have you reviewed?
We have.
We
We have. We
Any
stipulate to the
additional
findings.
evidence?
No additional evidence.
Any additional evidence of the people?
No.
The court would find that the defendant is competent to stand trial.
Thank you.
Court specifically would indicate that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. So I'll need an order on competency.
I did submit one to the court, Your Honor.
You did?
I did.
And now what did you want to do?
I'm just asking for a 2-week adjournment.
That probable cause conference in this case then will be set for February 26th, 2026, 9 a.m. as your bond, or as your invite indicates. Bond. Continue.
Thank you very much. We will be in touch.
Court calls case People versus Samira San Paulo.
And this is on behalf of the people.
Roberto, on behalf of Ms. Dampolo, Samira, please unmute yourself, state your name for the record.
Samira Dampolo.
Thank you, Your Honor. At this time,
Thank you.
Thank you, Judge. At this time, discovery is complete. We are asking that the matter be set for preliminary exam.
People have their witnesses available the 24th.
We'll do our best, Your Honor.
Preliminary examination will be set.
Excuse me, I have a
February-
question. You know, I am in one court, important for me, but you know, I don't know. So,
Excuse me? Oh, that was not her. Okay. In the Danpoyo matter, the matter will be set for preliminary examination February 24th, 2026, 9 a.m. before me. Bond will continue. Thank you.
All right. You can log off, Samira. You're all set. Thank you, Judge.
thank you.
Court does call the case People versus Ronald Fleming.
No, it's not me. No, soon.
Assistant Public Defender, I'll stand in today for Mr. Johnson, if Mr. Fleming allows, Your Honor. My understanding is Mr. Johnson's unavailable. My understanding is that he has communicated with the people. I'm sorry, step in for record, sir.
Ronald Fleming.
My understanding is that he's communicated with the people and with the court that he's requesting an adjournment on the file.
Who's requesting an adjournment?
Attorney Johnson, Kareem Johnson.
Oh, you're standing in. Do you have any objection to him standing in, sir? Pardon?
No, sir.
All right.
I can't hear anything.
Did he indicate how much of an adjournment or how long?
He said that he would communicate with the prosecutor and the court directly about a next date. I'm assuming he did not do that since you're looking at me.
I have not heard.
So I would ask for 3 weeks, I guess.
I have no objection to 3 weeks. I don't have an exact date. And we call me with a.
March 5th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Thank you.
Thank you.
I'll need a green sheet submitted on his behalf, Mr. President.
And here's the turning point: failure to appear. Despite findings of incompetency but restorable status, absence triggers a bench warrant and a $10,000 cash surety bond. No delay, no warning. Court procedure moves swiftly. Missing court doesn't pause the system, it escalates consequences immediately.
Court does call the case of the People versus Joseph Hodson. All 4 cases.
Judge Cabral, on behalf of Mr. Hodson in the matter ending in 5232.
Assistant Public Defender Ben Dunaway for Mr. Hodson. We have co-counsel Kyle Riedel.
I'm on Zoom, Mr. Denowith.
Okay, so where's your client?
Your Honor, this is the date and time set for a competent review hearing. Unfortunately, I've placed several phone calls to the number we have for Mr. Hodson, as well as emailed him without success. Mr. Brito, have you been able to contact our client?
I haven't either. I don't believe I have a good phone number for him.
So, Your Honor, given that the forensic center found him incompetent but restorable, we'd ask for an adjournment for 2 weeks so that we could attempt to contact him.
And I would join in that motion on my case as well.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of 10,000 cash surety. Those warrants will issue immediately on all these cases. Thank you.
Thank you, Judge.
Court calls the case People versus Kurt Rushland.
Morning, Your Honor. J. Grant Miller, P58658 on behalf of Mr. Bushline, who approaches. Your Honor.
Your name, sir?
Kurt James Bushline. Your Honor, I believe we have a resolution in this case, but it's contingent on Mr. Bushline taking a plea up in Ithaca County. I believe that's set for March 16th.
Yeah, I guilty.
The sentencing date on the case in Gratiot County is March 16th. And I misspoke, Gratiot County, Your Honor.
Which is it. So we're asking to adjourn until after the sentencing date so that we can then.
So it isn't a plea, it's a sentencing date.
He entered a plea up there, Your Honor. He'll be sentenced on the 16th. The offer from the people was, the plea was after.
Probable cause will be adjourned March 19th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Calls case People versus Jaleesa Robinson.
Morning, Your Honor. J. Grant Miller, P58658 on behalf of Ms. Robinson, who should be on Zoom.
Ma'am, state your name.
Jaleesa Robinson.
Thank you.
Your Honor, we're discussing the negotiations. I believe there is a discussion of an amount of restitution. We're asking for an adjournment after March the 1st to see if my client can come up with those funds.
Cause conference March 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Matthew Kennedy.
And Assistant Public Defender, Shanazia Terry, I can rule Your Honor on behalf of Mr. Kennedy. Is it? I have
One?
Yes.
Okay. And good morning. Go ahead.
PD's on a 22 matter.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Mr. Kennedy as it relates to the 26 matter.
Okay, what are we doing? You're asking for an adjournment.
We both are, Your Honor, so.
Probable cause conference March 5th. Is he held on anything else other than these?
I don't, do you have another hold?
Just these two cases, right?
I think it's just
Just these two cases, Your Honor.
Probable cause conference February 26, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
And just for the court's information, I did see some out of county traffic rules.
Oh. Yeah.
Okay. Thank you.
I'll see you for next. All right.
Court calls the case People versus Gary Coward.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Gary Coward. Your Honor, discovery is complete in this matter. We're requesting exam. Oh, thank you.
People have their witnesses available the 24th. Preliminary examination in person, February 24th, 2026, 9 a.m. Bond before Judge Barr. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus William Matthews. Then let me try to get Ms. Petoskey.
William, state your name. William Herman Matthews, Jr.
He's waving.
Judge, yes, but before he waives, Your Honor, while this court has jurisdiction, I'm asking if his phone privileges can be restored. I'm not quite sure why it was nothing nefarious on his behalf, but we're asking that the court restores phone privileges. And then we're going to waive up the circuit court.
I didn't know.
Pardon?
Everything's turned off. I can't go to store. I can't do anything. Nobody know why.
When are you saying this court revoked it?
It wasn't a court. It was somebody in the jail, I guess. I don't know. I've been trying to find out for 2 weeks. And they just keep saying it won't accept my,
Does the people's file reflect that I revoked it?
I reflect this is the first time it's even been in this court.
That's right. That's what I have. So I don't know where.
Something wrong with the jail, I guess. I don't know.
Can you be of any assistance?
I could, but I won't because it's not my order.
All right, I'll discuss it with the
Is
jail.
he gonna waive?
Yes, Judge.
Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
You will also waive the right.
That's right.
Preliminary examination having been waived, defendant bound over to circuit court on a single count. Mr.
Judge, we acknowledge receive the information, waive its reading. My client would stand mute.
Defendant ever waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
February 26th at 1:30 with Judge Slay.
February 26, 2026, 1:30 before Judge Slay.
Thank you, Your Honor.
Thank you. Bond will continue.
Thanks, Judge.
Thank you. Court does call the case People versus Abdul Latif.
Ready, Judge.
Good morning, Your Honor.
Still speaks to Assistant Public Defender on behalf of Mr. Abdul Latif, who appears to be on Zoom. Please take your.
Sir, I'll need a camera and to state your name, please.
Good morning, Your Honor. This is Abdul Latif.
Thank you, Judge. We are requesting a brief adjournment to determine whether or not a motion is going to be
And
filed.
you'll explain to your client next time he's in court, so he shouldn't have his hand everything on.
Yes, Judge.
All right. I'll adjourn this matter. Probable cause will be adjourned to March 5th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Thank you, Judge.
Court calls the case People versus Theodore Enke, maybe.
Good morning, Your Honor. Kennedy on behalf of the people. To carry out.
No, take your time. We're good.
That was moving fast. Your Honor, on behalf of Mr.
Your name, sir?
Ankney. Judge, we need to, I put in a request for investigation, so we need to explore that a little further. That's why we're asking for an adjournment.
Is this the only thing holding him, or?
It is.
It is. Is 2 weeks going to be enough, given what you want to do, or you need 3?
Let's do 2 weeks for
2
starters.
weeks,
Yes.
right. Probable cause conference, February 26, 2026, 9 a.m. Bond continue. Thank you.
Thank you.
Court recalls the case of People versus Margaret Petoskey.
Joy Gaines, Assistant Public Defender, representing Ms. Petoskey. Thank you, Your Honor, for the moments to get everything in order.
Your name, ma'am? I need her unmuted.
A calmer but emotional moment unfolds. The defendant prepares to plead no contest to methamphetamine use. The judge carefully explains rights, penalties, and consequences. Anxiety shows, but the process continues methodically. This is how plea hearings work: slow, precise, ensuring the record is absolutely clear.
Ma'am, can you state your
Petoskey.
name?
Margaret Petoskey.
Thank you.
Mm-hmm.
I have a plea form before me that indicates that the defendant is going to be pleading no contest to the charge of use of methamphetamine, the 1-year offense. Upon our successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct, Your Honor.
Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Margaret Petoskey.
Okay, you can put your hand down. Ma'am, it is this court's understanding that you're going to plead no contest to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Yes.
All right. You understand what a no contest plea is?
Yes.
2 things about a no contest plea I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea.
Potential civil liability.
Ma'am, to the charge of use of methamphetamine, how do you plead?
Guilty.
Really?
No contest.
No contest. I mean,
Thank you.
I've been trying to get this over with since December 12th. I'm sorry. I'm having a little anxiety right now.
Okay. All right. You understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
All right. You had signed or caused to be signed an advice of rights on your behalf?
Yes, I hope so.
Well, did you give your attorney permission to sign the advice of rights?
Yeah.
Okay, after going through that with her?
Yes.
All right. Do you have any questions regarding any of those rights?
No.
You understand that you're giving up all those rights, including your trial rights, which are contained under paragraph 5.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole? No.
I was supposed to be released from MDOC on December 2nd, and this is holding me up. So I will be on parole once I get out.
All right, but you are not currently on parole.
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, sir.
All right. Court has been provided and has reviewed Michigan State Police report. I think was the number. Really? I don't need all this stuff. Michigan Department of State Police report for their case number 720724. Any objection to the court having reviewed that report?
No, Your Honor.
Since I'm going to just get rid of this, it's my case anyway. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine defendant's guilt of this offense. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, thank you, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Ma'am, anything you or your counsel want to say before I impose sentence?
Your Honor, Ms. Petoskey does have 62 days of credit as of today, and she has no objection to immediate sentencing and is asking for a sentence to 62 days of credit for time served.
Ma'am, anything you want to say?
Just that you would take that into consideration, please. I have completed everything I needed to do here. I completed my building trades for Volk Village. While I was waiting to be sentenced with you, I've completed ServSafe. I just really want to go home.
Understood. The sentence of the court, $125 state minimums, 62 days in jail, credit 62 served. You're all set. Good luck to you, ma'am, when you get out.
Thank you.
Thank you.
Thank you, Your Honor. Good luck, Ms. Petoskey.
Court calls the case, People versus Andrea Acre. I'm not doing that again.
Public Defender Chinazi Kyriak Kimberly, Your Honor, on behalf of Miss Andrea Acre.
Acre. Okay. Acre,
Yes,
state your name, please.
Andrea Acre.
And I submitted a green sheet. We're going to be asking for an adjournment to explore a potential conflict that we identified. The people have extended an offer, but I need to confirm if it's a conflict in my offer.
Probable cause conference, March 5th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Oh, yeah, that's
You say, ma'am?
No, I was going to say something. I was thinking I had an appointment then, but a doctor's appointment, but I don't. I'm good. Yep, that's perfect.
All right. Thank you.
Yep.
Court calls the case, People versus Kristen Anthony.
Glenn, on behalf of Ms. Anthony, can you please state your name for the record, please?
Kristen Nicole Anthony.
Thank you.
Your Honor,
Go ahead.
in this case, we would like to, our client would like to waive her right to a preliminary exam.
She wants to waive up.
Yes.
Is that correct, ma'am?
Yes, Your Honor.
You understand that preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you will not have that hearing
Yes,
and
Your
that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on all 4 counts.
Thank you, Your Honor. We also would like to request that our client can be released to inpatient treatment.
Sorry.
Your Honor, we will waive formal reading of the information and we ask that you set this for pretrial.
Defendant having waived formal reading, your client is standing mute. Is that correct?
Yes.
Defendant standing mute. Court will enter a not guilty plea as to all 4 counts. Pretrial will be set for
February 23rd at 1:30 for Judge Hamoud.
February 23rd, 2026, 1:30 before Judge Hamoud. Bond will continue. I will sign an order. You get it into me today for jurisdiction is absolutely lost for a release to inpatient. Otherwise, you'll have to take that to Ms. Hamoud, Judge Hamoud. You have it here. Any objection from the people?
Yeah, we do object to the police treatment. As I recall, this defendant in a prior release to treatment or trying to get into treatment, I think while on bond, if I remember correctly, again used the victim's insurance. insurance information to try to get into treatment. So I don't know that it's appropriate.
Did she do that I mean, or are you just suspecting she did?
That's my notes are, my case notes are saying that we got information on December 1st, the defendant had used the victim's insurance to try to get admitted to a treatment facility. Before she was arraigned in this case.
Before what?
Before she was arraigned in this case. I apologize.
So she tried to do that on another case? Is that what you're telling me?
On another date, yes, in December.
I was tired.
I think people can raise that before Judge Hamud as to how that's going to occur. I'm going to sign the order. I'll release you to treatment. And then Judge Hamud can deal with it. Thank you. Court does call the case People versus Nico Caillou.
Christina Sachs on behalf of Nico Siu. I'm standing in on behalf of Edward Drucas, CEO's permission. Is that correct, Mr. Siu?
We're trying to get him unmuted. Sir,
My name
state
is
your
Mr.
name.
Caillou, but good morning, Your Honor.
Good morning, sir. All right, you have, your attorney is Mr. Drucas. You don't have any problem with counsel stepping in at this point, do you?
No, I do not.
Okay.
Your
You're
Honor,
requesting an adjournment?
Yes, for Nido discovery.
Is this the only thing holding him? Do we know?
I do not know yet.
Man, you got any other cases holding you right now?
Your Honor, he does. He does have a few other matters. One he's recently arraigned on, and he has bonds on all of those.
Probable cause conference. I'll adjourn this to March 5th, 2026, 9 a.m. Bond continue.
I'm sorry, you'd say March 5th.
Thank you.
Thank
you, sir.
Thank you, sir. Have a good day.
From denied bond reductions to bench warrants, attorney withdrawals, waived exams, and negotiated pleas, this docket shows how procedure shapes outcomes. Every appearance counts, every condition matters. Court never slows down. Like, comment, and subscribe for more dramatic courtroom breakdowns and real-time legal insight.